We will now talk about criminal remedies. But before we proceed with criminal remedies in the Trademarks Act, let us understand the meaning of a few key terms. The first term defined in the Trademarks Act, which is of relevance here, is the meaning of applying a trademark. Section 101 of the Trademarks Act defines what is the meaning of applying a mark or trade description to goods or services. This section provides that applying a mark means applying it to goods themselves or use it in relation to services, or applying to any package of the goods, or placing, enclosing or annexing any goods which are sold, exposed for sale or had in possession for sale or for any purpose of trade or manufacture with any package or other thing to which a trademark or trade description has been applied. As you would have noticed, applying a mark includes both applying it on the goods themselves or services, or applying it to any packaging pertaining to the same, and also includes placing those physical goods at any location. This also includes use of a trademark or trade description in any manner that will reasonably cause people to believe that those specific goods or services are sold under that trademark. It also includes relation to the goods or services, a trademark or trade description, sign, advertisement, catalogue which is delivered to a person pursuant to a request or order made by reference to the trademark or trade description in question. A trademark or trade description is also deemed to be applied to goods when it is actually physically woven in, impressed on or otherwise worked on or annexed to the goods or products or their packages. The second meaning that we need to understand is falsification of a trademark. Under section 102 of the Trademarks Act, it is described when a person is deemed to falsify a trademark, and this includes when a person without the assent of the proprietor of the trademark makes the trademark or a deceptively similar mark. Secondly, when a person falsifies any genuine trademark by altering it, adding or otherwise. A person is also deemed to falsely apply a trademark when such person without the consent of the proprietor of the trademark applies such trademark or a deceptively similar mark to goods or services or any package containing goods, and uses any package bearing a mark which is identical or deceptively similar to the trademark of the proprietor for the purpose of packing, filling, wrapping goods or services other than those which are genuine products of the proprietor. Prosecution for falsifying a trademark or false application of a trademark, the burden of proving that the accused had consent of the proprietor lies on the accused. We will now talk about the offences that are provided in the Trademarks Act. Section 103 of the Trademarks Act makes the following acts punishable. First, falsification of a trademark. Second, falsely applying to goods or services any trademark. Making, disposing of or having in possession any die, block, machine, etc. being used for falsifying a trademark. Applying any false trade description to goods or services. Applying to any goods or services any indication in violation of section 139 of the Trademarks Act. Tampering with, altering or removing an indication of origin which has been directed under section 139 of the Trademarks Act, and causing any of these acts to be done. Unless one proves that he or she acted without intent to defraud, punishment for these acts is a term which shall be not less than 6 months and which may be extended to 3 years, and with a fine which may not be less than 50,000 rupees but which may extend to rupees 2 lakhs. The court may, for adequate and special reasons that it has to mention in its judgment, impose a sentence of imprisonment for a term less than 6 months or a fine less than 50,000 rupees. There are certain exceptions to this penal provision. Those exceptions are provided in section 112 of the Trademarks Act. When a person accused of an offence under section 103 proves that in the ordinary course of his business, he is employed on behalf of other persons to apply trademarks or trade descriptions to make dies, blocks, and that in the case which is the subject of the charge, he was so employed, he was not interested in the goods or other things by way of profit or commission dependent on the sale of such goods, and that having all reasonable precautions against committing the offence charged, he had at the time of commission of the alleged offence no reason to suspect genuineness of the trademark or trade description, and that on demand made by or on behalf of the prosecutor, he gave all information in his power with respect to the persons on whose behalf the trademark or trade description was applied. Such person shall be acquitted. So, to get an acquittal for an offence under section 112, the accused will have to prove 4 things. First, that in the ordinary course of business, he was employed by someone for doing the infringing act. Second, he had no interest in the sale of those goods. Third, he had no reasonable reason to believe that the acts were infringing. And fourth, that he has fully cooperated with the prosecutor and provided all information about the person on whose instructions he had committed those acts. We will now cover the second penal provision in the Trademarks Act, which provides for penalty for selling goods or providing services to which false trademark or false trade description is applied. You may recall that section 103 dealt with actually falsifying trademarks or falsely applying trademarks, while section 104 deals with penalty for selling or providing services to which false trademarks or trade descriptions are applied. Under section 104, a person who sells, lets or hires any infringing goods is liable for infringing the same, unless such person can prove that he had no reason to suspect the genuineness of the trademark or trade description, or he gave all information in his power with respect to the person from whom he obtained such goods or services, or that he had otherwise acted innocently. Such person shall be punishable with a term which shall be not less than 6 months, but which may extend to 3 years, and with fine which shall not be less than 50,000 rupees, but may extend to rupees 3 lakhs. As in the case of section 103, a judge has powers to reduce the sentence beyond the minimum prescribed and reduce the fine beyond the minimum prescribed, subject to recordal of reasons in the judgment. Now, section 120 of the Trademarks Act also punishes abatement of offences under the Act. We have now concluded the section on criminal remedies. We will briefly touch of a third kind of remedy that is available to right holders in India. These are the border control measures. Under the Intellectual Property Rights Imported Goods Enforcement Rules 2007, a right holder can record or register its rights with the customs. The customs in return will identify infringing goods or suspicious goods and inform the right holder to take action. We will now summarize the module for today. We started with civil remedies that are available to a right holder. We discussed both permanent reliefs and interim reliefs. In permanent reliefs, we discussed injunctions, damages, accounts of profit, delivery up. In interim reliefs, we discussed interim and ex parte injunctions. We then spoke about ante and pillar orders, Mariva injunctions and discovery orders, including Norvik Pharmacal orders. We then discussed criminal remedies under trademark law and discussed the meaning of falsification, falsely applying trademarks. We then discussed provisions of section 103, section 104 of the Trademarks Act, and whether abetment of infringing acts is also liable in India. And we concluded with a brief discussion on border enforcement mechanisms that a plaintiff may use to enforce its trademark rights in India. Thank you.